right to marry is wrong. By Anand Grover. The Supreme Court of India's line with respect to same sex persons that there is no fundamental right to marry is incorrect. So, we have it from the Supreme Court of India in Supriyo Chakrabarti. There is no fundamental right to marry, it holds. On that account, the court decided that same sex persons cannot marry. In my view, this is a wrong decision. However, to the credit of the court, it directed unanimously that same sex couples have to be protected from any harassment. The court also passed directions to sensitize the authorities on this behalf and even directed the setting up of a community to look into a number of issues. However, the flaw is fundamental and it needs to be corrected sooner than later. To understand Supriyo Chakrabarti, we need to contextualize it. In 2009, the Delhi High Court read down section 377 of the Indian Penal Code IPC in NAS Foundation NAS that was set aside in Suresh Kumar Kaushal by the Supreme Court in 2013 but ultimately upheld NAS in Navtej Singh Johar in 2018. Section 377 IBC, a law made by the British that criminalized sex between non-heterosexual couples, was punishable with 10 years imprisonment. As a result, the LGBTQI communities suffer blackmail, torture, violence, harassment at the hands of the police, their lovers, and families. A gay man, for instance, could not disclose his orientation for the fear of reprisals. This is what I heard from clients who began coming to the Lawyers Collective from 1997 when we took the decision to challenge the constitutional validity of Section 377 in 2001. Both NAS and Navtej Johar did not strike down Section 377. They held that adult non-heterosexual couples having physical relations with consent in private would not be criminalized. In the meantime, even before Navtej Johar, the court had held in Nalsa that persons are entitled to identify their own gender. They may be born as males, but if they want to identify as females or transgenders, they are entitled to do so. Pursuant to that, the Transgender Persons Protection of Rights Act was passed by Parliament, which provides the procedure for changing one's gender and protection against discrimination in diverse establishments, private or state. A stigmatization. It had also been held by the court in diverse decisions that in India a person is entitled to autonomy, dignity, privacy, and the right to choose their own partners to live with or in marriage. Obviously, after Navtej Johar, when one can have intimate relationships with a person of any gender or sexual orientation, it is logical to assume that in that situation, when a couple are having a physical relationship, they may prefer to develop a long-term relationship, including that of marriage. For marriage brings along with it a host of advantages for couple, including succession in the field of inheritance, adoption of children, taking decisions in case of hospitalization, and benefits from the employers. More than anything else, in the eyes of society, it sanctifies the relationship beyond reproach. A relationship less than marriage is not considered by the society to have the same legitimacy. Without that legitimacy, LGBTQI communities are stigmatized. Consequently, LGBTQI communities began making strong demands for their right to marry. Petitions were filed in the Delhi and Kerala High Courts, which were all transferred to the Supreme Court, where two fresh petitions were filed. It is in this background that the court in Supriyo Chakrabarti was asked to decide the right of recognition to marriage by the state of non heterosexual couples. The Human Rights Declaration. The fundamental core decision of the Supreme Court in Supriyo Chakrabarti is that there is no fundamental right to marry in India. In arriving at this decision, the court ignored the fact that India was an original signatory to the Universal Declaration of Human Rights UDHR, the founding document of all human rights in the world. It is well known that the Indian Constitution was greatly influenced by the UDHR. As a signatory country to the UDHR, legislation by Parliament and state legislatures in India must be in accord with the UDHR. More importantly, courts in India have interpreted the Constitution and statutes in line with the UDHR and other international covenants. Article 16 of the UDHR 1948 provides that men and women of full age without any limitation due to race, nationality, or religion have the right to marry and to found a family. Under the UDHR, the right to marry is a human right. In the face of this, can it be argued that it is not a fundamental right? Critics would argue that the Indian Constitution does not provide for the right to marry explicitly. However, this ignores the Indian constitutional jurisprudence, where the courts have interpreted constitutional provisions and enunciated new preamble rights to a liberal and expansive manner. The Supreme Court of India has read the rights to be treated with dignity into Article 21, a classical negative covenant on the state. It is on that basis that positive rights, including the rights to education, food, environment, have been evolved. The Supreme Court has used the provisions of UDHR to elaborate rights under the Constitution. Thus, in the context of handcuffing and consequential torture contrary to Article 21 of the Constitution, in Prem Shankar Shukla, the Supreme Court referred to Article 5 of the UDHR stating that, after all, even while discussing the relevant statutory and constitutional requirements, court and council must never forget the core principle found in Article 5 of the Universal Declaration of Human Rights. This was reiterated in Francis Coralio Millen, which, based on the concept of dignity, stated, "It would thus be seen that there is implicit in Article 21 the right to protection against torture or cruel, inhuman, or degrading treatment, which is enunciated in Article 5 of the UDHR. In Maneka Gandhi, the Supreme Court relied on Article 10 of the UDHR to read the principles of natural justice into the administrative process to state, hark back to Article 10 of the UDHR to realize that human rights have but a verbal hollow if the protective armor of Audi, altered, parted is deleted. Thus, it was eminently reasonable to develop the concept of the right to marry into Article 19 and 21, especially because the right to intimate relations is now recognized in Supriyo Chakrabarti itself. Surprisingly, the court says that we cannot use foreign jurisprudence in the case of legal issues relating to marriage, despite the fact that in Supriyo Chakrabarti, the court has introduced the doctrine of intimate association borrowed from the jurisprudence developed in the United States. on transgender persons. The irony is that for transgender persons, the code holds that marriage between a trans man and a cis woman or between a trans woman and a cis man is legal. That is correct. But there lies irony. It needs to be appreciated that, according to the logic of the judgment, marriage is only legal between a man and woman, that is, biological man and women. The court has rightly made the leap from the biological sex to gender, which is self identified in accordance with NALSA. If the leap was possible for biological sex to self identified gender, it is difficult to understand why a leap could not be made from biological sex to sexual orientation. After all, not recognizing marriage for same sex couples is not only discriminatory against them, the unintended consequence of the judgment in the larger society is that the notion that the same sex couples are not fit for marriage will be perpetuated. It now has the imprimatur of the highest court. It reduces them to second class citizens. The sooner this wrong is set right, the better it would be for society as a whole. My message to my LGBTQI colleagues is that fighting involves falling several times before the ultimate victory. We fell after Kaushal, but we fought and won in Navtej. Now we need to get up and fight and win again, which we shall do.